thank you for joining us for this very niche and not at all timely panel on democratic will and constitutional guardrails, the referendum question in a divided Canada. What a wild time and place it is to be thinking about these questions on the quality of democracy, the use of referendums, and the role of the Constitution in Canada. My name is Erica Rayment. I'm an assistant professor in the Department of Political Science at the University of Calgary. I'm thrilled to be here moderating this panel, joined by a really fantastic panel of folks who I think will have lots of interesting and insightful things to say on this topic. No pressure whatsoever. But I'm going to quickly turn the floor over to the panelists so that they can introduce themselves and share a little bit about their connection to this topic. So, Richard.
I am Richard Mailey. I'm the director of the Centre for Constitutional Studies, which is a research and public education hub at the University of Alberta. I'm from Northern Ireland originally, and I came to Edmonton via Scotland and Luxembourg.
All right, I'm Colin Feasby. I'm a judge of the Court of King's Bench. I work just a few blocks from here, and I have a long-standing interest in democracy issues.
And I'm Jared Wesley. I'm a professor of political science at the U of A, co-lead of the Common Ground Project.
Awesome. Thank you so much to all three of you for being here. Before we get started, I think we have one of those cool Mentimeter questions ready to go for this panel, so I don't know if we can put that up. Oh, there it is. So the question is, do you believe referendums strengthen or weaken democracy? So there's a lot going on in Alberta right now with talk of separation, citizens' initiatives, referendums, and the constitutionality of all of these efforts. And while I think there's a lot to say about the sort of substance of these efforts, and other panels are covering that aspect of things, our goal here in this session really is to just kind of nerd out on the institutions side of things, and to think through this question of what happens when direct expressions of democratic will collide with constitutional requirements, and how do we adjudicate the tensions that emerge there. So we've got about 40 minutes, and I want to leave time at the end for audience questions, because I think this is probably a topic that folks are probably having some questions about. So I'm just going to get right into it. But to get us started, I'm maybe going to turn things over to Jared to give us the kind of speediest, high-level lay of the land on where things are at with referendums in Alberta right now, because I realize not everyone is sort of from Alberta and consumed with all of the goings-on on this front. So, Jared, what are the questions that are currently on the agenda or waiting in the wings? Where are they coming from? How do they get onto the agenda? And what obstacles are they bumping up against?
Thanks, Erica. I find it really ironic that we offered 4 options on the questions about referendums, because referendums are dichotomous questions, and that's part of the problem. But, I'm just going to give a high-level overview of how we got to be where we're at right now, and the story very quickly starts in 2019. Jason Kenney, a few years earlier, had come back to first become leader of the Progressive Conservative Party and then merge the Wild Rose and PC parties together, and crucially proclaimed the UCP to be the most grassroots party in Canada. And some of the institutional choices he made there made it a lot easier for a small group of party members to exert all kinds of pressure on the Premier, which he found out personally. But in the meantime, after he won the 2019 provincial election, that fall, the federal election happened, and Justin Trudeau's Liberals formed a majority government despite not winning the popular vote. And that was a major disappointment to Conservatives, which has a beachfront here in Alberta, beachhead, I guess, beachfront property. Many do have beachfront properties, but that's beside the point. But after that election, separatism spiked. According to our own research, it reached as high as 30%. And Kenney was faced with a real challenge and a question. Does he want to try to maintain the separatists within his own party, or does he want to excommunicate them, essentially? And he chose to try to keep them within the Conservative coalition. And he did so in a couple of different ways. First of all, he amended the citizen initiative and referendum legislation to allow this type of petition to spark a referendum in the first place. His thresholds were very high when he established it. That's crucial, because we find out later. But secondly, he did a fair deal panel where he toured around the province listening to grievances from Albertans, and then he called his own constitutional referendum on equalization, which in his own words was not intended to spark an actual constitutional change, in his words and his pronunciation. It was about gaining leverage with the rest of Canada for other federal provincial concerns, including fiscal stabilization. Fast forward, the changes that he made to the UCP Constitution, or the founding Constitution itself, made it easier for separatists and other folks who were anti-vaxxers to oust him from power, and Danielle Smith came in on a platform of being even more grassroots and was even more, I would say, beholden to the Take Back Alberta turned Stay Free Alberta separatist faction. She made several other changes to referendum legislation that made it even easier for a petition to spark a province-wide referendum, including lowering the signature thresholds, extending the amount of time you had to collect signatures, and then attempting to shield petition questions from judicial review. In the meantime, another petition had circulated around the province called the Forever Canadian petition, which was trying to pose the question, should Alberta stay within Canada, not should we leave? That one collected over 420,000 signatures that were validated by Elections Alberta. And the Stay Free Alberta separatist petition circulated around the same time and claims to have collected 300,000 signatures. However, that number has never been validated because courts, for reasons that we'll talk about probably today, have decided that that petition was not valid, should not have been sanctioned, and Elections Alberta is not allowed to count those signatures. And in the meantime, there was a massive breach of Alberta's electors list, which means that those 300,000 signatures may not have actually been collected legally. I think we can say we're not certain of the answer to that question. So that's how we landed today. In the meantime, the Premier Smith had also put 9 other questions on a referendum this fall. 5 of those questions relate to the ability of immigrants to this province to receive public services, and 4 of those questions relate to constitutional changes, much like the equalization referendum that Jason Kenney had, that would involve things like the provincial government getting to choose select judges in the province, among other things. So that's, I'm sorry, in a very, very short period of time. For those of you that haven't been here, it's been a bit of a ride since 2019 here in Alberta, but that's how we got to be where we're at.
Yeah, amazing. So everything's going super well, no hiccups at all. So it seems though as though referendums are having a bit of a moment in Alberta politics right now. So my question that sort of emerges for me then is this actually a new development, or has it ever been thus, right? So I've only lived in Alberta for about 5 years, and it seems to me as a relative outsider to Alberta politics that Albertans really do love them some direct democracy, like the grassroots politics that you were talking about, right? That's very much a kind of a thread and a current that runs through politics in this province. So I'm curious to get sort of a more rigorous assessment from the panel of, is my vibes-based assessment accurate, right? Are referendums actually becoming a more widely used political tool, a more kind of widespread feature of political discourse? And if they are increasing, why might that be the case? What are some of the factors that might be driving this? I don't know. Richard, did you want to get in on that first?
Sure. Yeah, that's already a tricky question to answer, actually. So referendums, and I'm never actually sure whether to say referendums or referenda. Can we have a referendum on that? It would be helpful to me. So referendums are these really seismic moments in the life of a political community, but in Canada, they're actually not that unusual, albeit with a qualifier. So if you look back at this sort of the expanse of the history of the Canadian state, I don't know the exact number, but my estimate is that there have been roughly 1 referendum every 2 years since 1867, roughly. The vast majority of those are provincial. So certain provinces use them a lot, certain provinces use them a little bit less. BC, I think, has had somewhere in the vicinity of 15, including 3 pretty notable recent ones on electoral reform. So lots of provincial referenda. Once you start to look at specific categories of referenda, things get a little different. So I want to talk about 3 categories. Federal referenda, constitutional referenda, and secession referenda. I'll do secession referenda once because it's the easiest one to deal with and set aside. We all know that there have only been 2 secession polls in Canadian history, both in Quebec in 1980 and 1995. When we moved to federal referenda, there have actually only been 3 since 1867. So there was one on prohibition in 1898, one on conscription in 1942, and then the best known one was the referendum on the Charlottetown Accord, which was this massive sweeping package of constitutional changes in 1992. That overlaps then with constitutional referenda. The Charlottetown Accord is one of the few constitutional referenda that we've had in Canada. So the Charlottetown referendum was actually 2 referenda. There was one referendum in Quebec and then one referendum in the rest of Canada. And the way that that referendum functioned was pretty typical as part of a constitutional amendment process. So if you look around the world, when states consider amending their constitutions, typically they consult the public. John Elster, a political scientist, says that they consult the public in kind of an hourglass shape. So public consultation starts off really, really broad and expansive. Often it starts with roving committees traveling the country and soliciting public opinion on what they want from the Constitution. Then public consultation narrows a lot. Then you get into sort of highly technical, behind closed doors drafting phases. And then once negotiators who represent a sort of plurality of different voices around the country come up with a draft package, that might then be put to a referendum as the final phase of the process, or at least as part of it. So during the Charlottetown period, the referendum wasn't actually a necessary step in ratifying the Charlottetown Accord. It was a first part of an informal part of that process. To actually ratify the Charlottetown Accord, you would have had to get formal consent from at least 7 provincial legislatures and the House of Commons and the Senate. So that's typically the way that referenda work. There's sort of a final threshold check to get a sense of, have constitutional drafters done a good enough job of doing something that, engages the public meaningfully, that satisfies what they want from their constitution? So that's the Charlottetown, like I said, you have 2 referenda during the Charlottetown period, one in Quebec, one in the rest of Canada. You then have to wait until 2021 and the referendum on equalization in Alberta. So Jared's talked about this a little bit already. The Kenny government held a referendum where they asked the public, do you want to remove Section 36 sub 2 from the Constitution Act 1982? That's the guarantee of equalization in the Constitution. A lot of people were perplexed about this at the time. Equalization is both a constitutional principle and a federal practice. So if you remove the principle from the Constitution, you don't necessarily end the practice. The turnout in that vote was low, grievously low, I think it's fair to say. But of the people that did participate, 62% voted in favour. So on the basis of that vote, the Kenny government passed a resolution in the House of Commons to amend the Constitution to remove Section 36 sub 2.
Alberta legislature, but yes. Just to clarify,
yes.
yeah.
So this technically started the clock rolling on the formal amendment process under the Constitution. If 7 provinces representing 50% of the population, plus the House of Commons, plus the Senate, had passed similar resolutions in their legislatures and in the Commons and the Senate, then that would have become constitutional law. None did, and so that initiative sort of fizzled out with a whimper rather than a bang after the 3-year clock expired in late 2024. And I think I'll end here because I've already talked for quite a while. That's an expansive history. But the referendum that we're going to be having in October, I think, follows that same template, and it's quite an unusual way of doing it. So this is using a referenda as a sort of to gauge public opinion right at the start of a potential constitutional amendment process that may or may not unfold, rather than as part of a ratification process.
Jared, did you want to maybe weigh in on, I'm maybe going to combine this with my next question, sort of what might be driving the kind of current fervor, if you will, for a referenda, right, with the 9 questions and then the sort of separation petitions, potentially soon to be referenda, sort of what might be kind of contributing to that, but then also what are the sort of tensions that emerge between the direct democracy on the one hand and constitutional democracy on the other hand, and do we sort of get to good outcomes with referenda?
Yeah, and so just to clarify, there have only ever been 9 referendums held in Alberta history to this point. There will be an equal number or more.
My 5-spaced analysis, not accurate.
No, yeah. So there will be an equal number or likely more referendums held on a single day, all on separate ballots in October of this year. So if you're asking if it's more than ever, yeah, it's more than ever on one day. But these referendums happen for a bunch of different reasons. I think you kind of covered some of them. Some of them are legally required. In this case, that's not met. Although if you want to spark a constitutional change here in Alberta, you need to hold a citizen referendum according to the Citizen Referendum Act, but that's not required here. The notion that you would have a referendum to endorse a deal or an accord like the Charlottetown Accord is another, I think, perfectly democratic use of referendums. To legitimize a government's approach to things, and this seems to be where the Smith government is going with their immigration questions, at least, where she said, we already know where public opinion is on these issues, so we're just going to validate that, right? And then that'll give us a legislative agenda to move forward. But again, they don't need to have that referendum in order to move forward with provincial legislation. Where I'm most worried, though, is that these referendums tend to be more of the strategic variety, not unlike Brexit. So strategic referendums are ones where the party leaders use to do a bunch of things. First, to maintain internal party unity, right? To put certain members of their base in check, to call their bluff, in the case of David Cameron in the UK. And those are worrisome for reasons that we know from Brexit. And a second reason to do a strategic referendum is to take control of the domestic policy agenda, to turn attention away from other issues that the government may not be handling well or may not be proceeding with public opinion in mind. And here we could say that they may be dodging some questions around corruption. They may be looking to reset the agenda away from healthcare and education. And the third is to gain the leverage that, I'm using his pronunciation again, that Jason Kenney talks about by saying that we have a public mandate now to negotiate with the rest of Canada. And so I think clearly all of these 9 referendum questions, possibly 10 or maybe 11 that fall on the fall referendum are strategic in nature. But to answer your question, how well does this fit with our system of representative democracy in Alberta and Canada more broadly? I'd say not very well. I'm just going to read the opening line from a book called Government by Referendum. It was written by Matt Kerftrup about the Brexit referendum, and then I'll close with his opening line. And it's a quote from William Keegan, who's a journalist from the UK. And William said, "Referendums are the nuclear weapons of democracy. In parliamentary systems, they're redundant. Seeking a simplistic binary yes-no answer to complex questions, they succumb to emotion and run amok, and their destructive aftermath lasts for generations." I talked earlier this morning about how pluralism is an art form of elite accommodation, and referendums are precisely the opposite, and that's why they can be so divisive.
Right. So in that instance, not always an expression of democratic legitimacy.
Well, I think people will say, well, we're going to let the people decide this, right? But referendum questions are crafted specifically by a group of elites to have the public answer the way that they want them to answer. And I would watch to see how the Smith government phrases this question that they're about to announce, in all likelihood, tomorrow night. Because she's already worded the other 9 questions in a way that is quite strategic, very long and convoluted. It's not straight up. But referendums are ultimately an expression of how elites want the public to answer.
Yeah. So I think there's this tension between sort of like what the quote-unquote people want and sort of how does that come up against what our democratic institutions will allow. And I think that there's an interesting rule here for the notwithstanding clause. So I don't know if folks were watching the Legislative Assembly last week, but the Premier stood in her place and she said, "We don't have a society governed by judicial supremacy, we have parliamentary supremacy." And this is sort of why we have the notwithstanding clause, so goes the argument, right? The idea is that you need to have the notwithstanding clause so that you can maintain that parliamentary supremacy and have the legislature overrule the courts. So I want to sort of put to this group of folks, maybe Richard, we can start with you. It seems to me that this is a very particular view of the relationship between Parliament, our representative democratic institutions, and the courts. So what is she sort of getting right with this assessment, and what might she be missing?
Yeah, it's a really good question. Okay, I would love to talk in detail about the notwithstanding clause. I'm going to evade it a little bit and go a different route, but then we can come back to the notwithstanding clause maybe. Okay, so the idea that we are or we live under a system that is committed to parliamentary supremacy. I will go back to one of the most famous Supreme Court precedents, or Supreme Court opinions rather, the Quebec secession reference from 1998. So in the secession reference, the Supreme Court tells what I think of as a story about who Canadians are and what they're committed to. And it tries to extract from that story a sense of how do we deal with the prospect of a secession vote. At the time, this would have been in Quebec. And in particular, how do we deal with the prospect of Quebec unilaterally declaring secession at some point? To tell that story, the court talks about an assemblage of different principles, that unwritten principles that are all parts of our constitutional order. It talks about democracy, talks about federalism, talks about the rule of law, constitutionalism, and protection of minorities. And from that story that it tells through those principles, it extracts this response to the legal question in that case. Here's the important part. The court asks itself, how do these different principles that are part of our constitutional order, these different things that we're committed to as Canadians, relate to one another? And I'll paraphrase. The court says, these principles relate to one another symbiotically. So no one principle can trump or exclude the operation of any other. Since that decision, and indeed before that decision, the court has recognized other unwritten principles that are important parts of our constitutional order, including judicial independence, the separation of powers, and parliamentary supremacy, or sovereignty. So parliamentary sovereignty is part of our constitutional order, but it's a part that has to be read in concert and alongside other fundamental commitments. So that would include things like protection of minorities, the rule of law, constitutionalism, judicial independence, principles that in a lot of ways sit less easily with the idea of the notwithstanding clause. I'll just say in closing, I'm sure a lot of people here are familiar with the Bill 21 litigation that's before the Supreme Court of Canada right now. And a few weeks ago, I read the Government of Alberta's intervener's factum in that case. And the government leans really heavily on two constitutional principles. It talks about the notwithstanding clause as being an expression of parliamentary sovereignty and as promoting the ideal of federalism. Now, you can frame it in that way, that can be true, but it completely ignores that other spectrum of principles that I've just mentioned, in particular, protection of minorities.
Great. So I think in light of this, the sort of nuanced relationship, if you will, between sort of Parliament and the courts, this sort of brings me to the next question, perhaps for Justice Feasby, on what is the appropriate role of the court in cases that involve the rules of how our democratic institutions operate?
Okay. That's not an easy question, and it's a question that legal philosophers have written great long books about. And it's also a question that I think reasonable people can differ on. And you see these differences coming out in some of the discourse about the court decisions. Some people think the court decisions are good and some are bad and some are democratic and some are anti-democratic. And realistically, these are all valid opinions. They're all opinions that can be defended reasonably. But my perspective on the role of the court here I like to explain it using an idea I take from Professor Ben Berger from Osgoode Hall. And he talks about judicial activism and judicial restraint. And when he talks about judicial restraint, he often talks in terms of judicial humility. And he said, what the court's job is to take up an appropriate amount of space. It's not about being as small as you can be. It's not about being arrogant and taking up too much space. It's about taking the appropriate amount of space. And the appropriate amount of space depends on what kind of case you're talking about. And when you're talking about a democracy case, and I'm going to just set the referendum stuff aside for a moment. If we're talking about a case where democratic rights are involved, well, it's interesting. Democratic rights in our charter are not subject to the notwithstanding clause. So any case that engages democratic rights is different and does call upon the court to look at it differently. What I would also say is when the legislature or when Parliament is making rules governing the electoral process, again, not talking about referendums right now, governing the electoral process, they are making rules governing their own election. And Justice Morgan, in the first working families case, because there's more than one, the first working families case, he says this puts elected representatives in a structural conflict of interest. So this isn't a conflict of interest they've gone out and sought. It's just inherent in the way our system is built. And because of that, it calls upon the courts to take a different role, perhaps a more critical role than they might take when Parliament or the legislature is making laws governing, how they spend the public resources, or even potentially on questions of social policy. So I would say, in that respect, democracy cases are different.
And so in terms of how the court approaches those democracy cases, there is a sort of different posture that the court adopts in relation to them then?
Yes, and so it's really a question of deference and non-deference. And one other thing I would say is there's also, when we're talking about democracy cases, there's sort of a practical approach that courts adopt as well. And I think you can see from that practical approach that there is a different treatment of these things. And I'll use the example, there's two cases this year out of the Supreme Court of Canada. One is the Terrebonne case about the contested election. And then there's the Lalonde case, which was about Quebec electoral boundaries. Now, normally the Supreme Court takes quite a while to decide its cases. Could take 6 months, could take a year. The Alawalia case about intimate partner violence just came out 16 months. But Terrebonne decided the same day, reasons to follow. Lalonde decided the same day with reasons to follow. And Lalonde, they gave the reasons within a month. So there's clearly a sensitivity to context at the Supreme Court that they realize that these cases are different and they demand a certain responsiveness. And I would say even in Alberta, you can look at the case I had on the referendum last fall. You can look at Justice Leonard's case this spring. These are cases that involved many, many parties. I had 12 or 13 parties in front of me, lots and lots of evidence, intervenor applications, the whole bit. We went from filing through a full hearing to a decision in 5 months. Which for anyone who's familiar with constitutional litigation is extraordinarily fast. So I think what you see is, from a practical sense, courts understand that these things are important and they move them to the top of the pile.
Fantastic. I'm getting notified that we have approached the time to open things up to audience questions. So I gather, is there someone in the room with a mic who can run that for us? If there's anyone who has a question, maybe we can put the Mentimeter poll back up on the screen, because I am struck by the significant portion of people in the room who, when asked, do you believe referendums strengthen or weaken democracy, answered, it depends on the issue or context. So perhaps you'd like to get some clarification from some of these lovely experts that we have at our disposal. Are there questions in the room? I know, it's the end of the day. It's hard. Oh, I see someone over here as well. Oh, and over here. Okay, we'll get you next.
Hi, thank you. Martin from City Calgary. My question, I know we discussed quite a bit of referendum, but one thing that's been happening in Alberta as well are recall petitions that's been prevalent. I believe there was 22 over the past couple of months. Now, I'm curious to hear from the panel's perspective, is recall petition technically some sort of referendum as well? Do these strengthen or weaken democracy?
Well, I think they weaken democracy. I don't think we need any more incentives for politicians to be shorter term in their thinking, and nothing's more short term in your thinking than looking over your shoulder and wondering if a very highly motivated, highly resourced group is going to recall you. It prevents you from acting as a trustee of the public good when you are sent to the legislature to decide on behalf of the entire province, if not the entire country, on some of these questions, if you're beholden to a small group of people. I believe in representative democracy. I think it works well, and it's most consistent with those pluralistic foundations we talked about this morning. But that's just one man's opinion.
I think there was another question at the table over here, if we can run the mic. Sorry, folks. This is a really big room.
Sorry, hi. You actually, Dr. Wesley, you made a comment about how referendum questions are kind of worded weird to where people in power usually get the answer that they want. What type of institutional things do you think we could do to combat that?
You're asking me how to fix a broken car. I don't think referendums are good for that reason in general. I mean, you could do referendum question writing by committee. I think the one safeguard in the case of a separatist referendum is that the federal government will have to make a choice. I understand within 30 days of the referendum question being announced and the referendum starting, the federal government has to choose whether they will view that separation referendum through the lens of the Clarity Act, and if so, they will have to then table that for a debate in the House of Commons and the Senate. Yeah. And in all likelihood, refer the question to the Supreme Court of Canada for a verdict on whether it is clear or not. And so on the big questions, like separating from the country, there is that safeguard in place, I suppose.
It's just the House of Commons, by the way. I nodded impulsively.
It looks like we've got a question at the front of the room over here, and then maybe one at the back once we've heard from them.
No, I'm not going to ask the question about what the hell is going on today. Instead, I want to go back to 2021, where we had a referendum in this province on switching to permanent daylight savings time. It got tossed by a very narrow vote, no. And now we're simply going to do it. And the Premier has said, if you don't like what she has done, you can organize a citizen's petition to get it on the ballot to reverse what we have just done. What does this tell us about the value of referendums?
Can I just add, really quickly, you raise an interesting point, Dwayne. Oftentimes, referendum questions are not only asked once. Think about it. This was the third time that Alberta had voted in 2021 on daylight saving time. The third time. And then fluoride, again, another couple. Prohibition, there were 3 referendums. Quebec sovereignty, 2 referendums. So if you think that a sovereignty or a separation vote here in Alberta is going to be the be-all and end-all, we're probably likely, if history is any lesson, to have another vote on that issue. But premiers are not above ignoring the results of quote-unquote binding referendums, because they're not binding. They're not legally binding. The Crown has ultimate sovereignty, and the government, by extension, is the one that makes the decision. The Yukon government was formed at the same time a referendum on moving to electoral reform was passed, and the premier just flat out on election night said, I'm not going to respect it because I don't agree with it.
I always find it really interesting that when I'm talking to classes about the 2021 referendum, I ask them if they remember the equalisation referendum. Everybody shakes their head. I ask them if they remember the daylight savings vote. Everybody nods. Everybody remembers that one. They don't remember the one that was actually about changing our constitution. So I think it's interesting that all of this attention was paid to one, and then the more significant one arguably flew under the radar.
As someone who very much does not want the sun to rise at 10 a.m. in the wintertime, I don't feel good about that one. I think there was another question in the back of the room.
Yeah, just wondering if the panel could comment. For those of us who have been following but maybe have not read in detail the legal decisions around the Alberta separation, can you talk us through the duty to consult or the role, the position of treaties with First Nations and how they impact whether a referendum can be asked and the stage at which the consultation needs to take place? I know it's a big question, so I know answer as you can in the time.
Okay, I guess I can't dodge that one. I did dodge it in my decision. If you look at it, I note that they raised the question, and I decided I didn't have to decide it. Justice Leonard wasn't in such a position. She had to decide it. I think the important thing that people aren't talking about is what the content of the duty to consult is, right? So there's a range of things that the law may require in the context of duty to consult. And I think there's been very little public thought or discussion around that point, and I think that that might affect how this issue is perceived. The other thing I wanted to say, because I think a lot of people have fixed on that, the duty to consult is not the only basis of her decision. And beyond that, I think we need to remember that when we look at these court decisions, they are being made in a context where there is really no precedent. So most of the time when I go to work and do my job, there's many, many decisions I can rely upon. There's in some cases in contract law, hundreds of years of worth of decisions. But this is a relatively new statute. There's not a lot of examples of similar statutes in other provinces, and it's really hard to figure out how it interacts with other established principles, like things like the duty to consult. So it is natural for people to find this challenging and wonder how it's going to play out in practice. Those are completely legitimate questions, and perhaps we'll get some further consideration from that from higher up the judicial hierarchy. But I don't think anybody should be surprised that these are subjects of public debate. That's to be expected.
I do see that there's another hand, but I'm getting signs from the front row that we need to wrap up. So in the name of getting us back on schedule, I am going to just briefly conclude by saying thank you so much to all of our panelists. This was super helpful, really insightful, grateful for your thoughts and insights on this. Thank you.